Welcome back to the Hexen Podcast, where we take marketing to the power of X. Joining us today again is Chris Combs, Steve Waterkotte from Combs and Waterkotte out of Clayton, Missouri. Today we're going to talk about orders of protection. So I think, Steve, this is, kind of your ballpark, right?
Yes.
You're very familiar with.
Do a lot of orders of protection. Almost probably 90% or more, 95% are on the respondent side. That is the individual that's served with the order of protection.
Oh, so you're defending more often than
correct.
Issuing. Interesting.
So we have in an order of protection proceeding, you have a petitioner and a respondent. The petitioner is the individual who is filing for the order of protection, otherwise commonly known as a restraining order. That is the person seeking to get a restraining order against somebody else. Again, that's the petitioner. And then the person who is served with the order of protection is the respondent, and that's who we primarily represent in these proceedings.
That makes sense. So let's go all the way to the beginning. What is an order of protection?
An order of protection is a petition filed in the circuit court. It could either be filed in the county in which either the petitioner or respondent reside in, or the county in which the alleged actions took place in. So usually it's filed in the county in which the petitioner resides in. And it is a petition, and they are asking the court to grant certain relief. And that relief is most commonly no communication, to refrain the other party, prohibit the other party from communicating, the respondent from communicating, from committing any kind of acts of violence or disturbing the peace of the petitioner. And there is usually a foot requirement in their request. And what I mean by that is the petitioner is saying, do not allow this person to come within 500 or 1,000 feet from me. And so those are the usual request for relief, and what the court will ultimately, most commonly grant if the order of protection is in fact granted after a hearing.
So you say you work with the respondent often. So how can I fight an order of protection?
Correct. So, there's a number of ways you can fight these. First off, I always tell folks, even if they may have done something wrong or, had a moment of lapse of judgment, acted irrationally perhaps, it's still wise to get counsel, an experienced attorney in this area. Again, it's a very niche kind of practice area where the laws are very defined. And if you don't practice in this area, you probably are not going to be that familiar. And so in many cases, even when I have a client that may have done something wrong, maybe even got violent, the law is very specific. And in many instances, it requires more than one incident. Not always, but in many cases, it requires the respondent to do more than just one thing. And so it's always wise to seek counsel when you're been served with one of these, because how this typically unfolds is you are served with a petition. You get a knock on the door or at work, handed over a petition with a number of allegations contained in there, a number of forms of relief the petitioner is requesting, and then they will typically set these for hearing within 2 to 3 weeks, sometimes even sooner. And so I always say, these are one of the fastest moving cases through our judicial system, and it's done so on purpose. There's a rationale behind it, because somebody may be in danger. They can't have a court date waiting 3 months out. Right. So they'll have a court date within 2 weeks. So when I get a call, usually somebody's calling and saying, hey, I have court next week. I have court in 2 weeks. And which is not an issue, but I always tell these folks is, hey, time is of the essence. You need to hire an attorney, because we have work to do on our end, and which, we're able to do. And we have a system in place for when we get these cases in our office. So we make sure we give them the proper attention and detail it deserves, and that we're well prepared walking into this hearing.
And one thing I'll say, regarding orders of protection, and this is my law partner's specialty, most of the case law out there on orders of protection, he's created, or quite a bit of it. But what I will say is it's a blend of criminal law, family law, and civil law. And what people don't understand is, oh, this is a restraining order. I don't care if I ever see this person again, right? So sometimes they just walk in there and they don't realize that judge can make housing decisions, like meaning you can be put out of your own home. They can make temporary custody decisions with children. So the gravity of what that judge can do, they can order you to do batterer's intervention. And again, this is Steve's specialty, but people walk in there thinking, oh, it's just a restraining order. I don't care if I ever see this person again. But the ramifications, again, can be immense, meaning, having a full order of protection against you is not good.
Wow.
And furthermore, people do not realize when they walk in that courtroom, it is not just about, hey, I have to stay away from this person. It can be the judge has broad discretion on what they can do.
Wow.
Yeah, and the fact of the matter is when it's gotten to this point, they're not calling me to say, hey, can you fight this because I still want to try to talk to them. The point is taken, right? They get served with an order of protection. They're not going, hey, I need to get a lawyer to fight this so you allow me to continue to try to be around them. I mean, nobody's calling me to defend these things for that purpose. It's the reasons that Chris just said, all these things that a judge can do, custody, the whole gamut of things that he just listed. So that's, and what we'll get to as well is that these things become part of your record.
Yeah.
And so that can have damaging consequences and ramifications as you progress through life and get jobs and things like that.
Let's say, like you presented it, the situation occurs and they think it's no big deal. So they go to the hearing and now they're compromised, and there's the defendant or the respondent is like, what I should have called earlier. Is there anything I can do? How can I appeal this order of protection?
Yeah, and it's funny you say that because we probably get a couple calls each week, that somebody in that exact situation thought it wasn't a big deal, or they say, here, I get this one a lot. These were BS allegations. I didn't think I needed a lawyer. Truth is on my side, which is probably all the more reason to get a lawyer, right? But I get that one a lot. We get probably 3-4 calls a week, folks that walked out of the courtroom and say that, I didn't think I needed a lawyer. And they went to the hearing and the order of protection was granted for a period of usually 1 year or more, and they're calling to try to undo this now. And I always tell them, I said, unfortunately, this process got a lot more complicated and expensive. Because now, like you just mentioned, we're talking about appeals. There's really only two things. We can do a motion to set that aside, which generally is not going to be, in most cases, it's not going to be effective. You're asking the judge to undo their ruling. I mean, it's like a parent that grounds a child, and then, your child comes and says, hey, can you vacate your decision?
It's like telling a judge, oh, you were wrong.
Yeah, and them saying, yep, you were right, and I'm overturning it. So, but that is a possibility, and we filed them in some cases when the facts, certain unique facts, circumstances. But in appeal, an appeal goes to a higher court. So you start at the trial court. Let's say we're in St. Louis County. Now, if you have to appeal that, you're appealing to the Missouri Court of Appeals, Eastern District. It's typically a 9-month process, give or take. Like I said, it becomes a lot more expensive, a lot more time consuming, and a lot more complex to try to undo what the judge already ruled on. I mean, that is always one of the most difficult task in the judicial system, is undoing, a judge's prior ruling. And so, and we do a lot of appeals, and we've been successful probably about 50% of the time, which is, it's incredibly high. I mean, the statistics in Missouri, most cases are affirmed on appeal probably at a rate of 95% or higher. And we are successful on our appeals. We do a handful each year in this area of law, and about 50% of the time. But again, it becomes more complex, it becomes more expensive and more time-consuming, but it can be done. Now, folks that show up for a hearing lose that, and they call and say, hey, what can I do now? We start talking about exploring the process of what an appeal looks like. And like I said, we do more appeals in this area than any other firm in the state of Missouri in this area. In fact, I just challenged, first ever challenge in Missouri, a newly enacted statute that allows judges to enter an order of protection for a period of up to 10 years.
Oh, wow.
And that's relatively new. Prior to that, you could only get one for a period of 1 year with an automatic renewal for a year, which in effect would be 2 years, obviously. And then it makes the petitioner come back each year and try to renew it and things like that. Well, the legislature created this new law that allows petitioners, in cases that meet certain requirements, to get an order of protection against the respondent for 10 years. And I had a case where I didn't represent the individual at the trial court level, but after the judge in that case ruled and entered an order of protection for 10 years, they called our office. I was very interested because, again, this hadn't been challenged yet.
Uncharted territory.
Yeah, I know it's the first appeal in this area. And so, we took the case on. It was going to be a difficult case. It was difficult facts, but nonetheless, we jumped in, very eager to do it. And we lodged the first ever challenge to that law in the state of Missouri. Unfortunately, we were not successful. That said, again, those facts were very difficult in that particular case. But we're proud of the fact that we did, challenge this, and it created some law in the sense that the statute it was fairly vague and broad. In the case that we brought, then the Court of Appeals kind of expounded on, what it requires a petitioner to prove to get that 10-year order of protection.
Wow. Well, that's a huge leap to make things like that happen in the
Yeah,
courts.
in a 10-year order, that's, I always say there's a stigma that attaches on these order of protection cases. You are labeled an abuser or a stalker or somebody who's sexually assaulted somebody. And so there is certainly a stigma that comes along with having one of these. These are on CaseNet. Everybody is familiar with CaseNet. Employers look that up, and you're going, whoa, that's a humongous red flag. If you were, you were doing a background check and you say, hey, this guy had an order of protection, entered against him. Now I'll do it for 10 years. And you're going, that's, you already have red flags under a year, but now a 10-year, certainly you're going, whew, that's, there's some serious red flags. What the hell did this person do, in order to have that order of protection against him for 10 years? So, that said, there is the law in it. It does require more than just the ordinary. There requires the court to make specific written findings on various things in order for them to justify the 10-year order. But the case that we did appeal, like I said, that kind of created law in that area and provided more context behind the new statute.
And one thing I think is very interesting, and Steve, I'd like you to tell this story. No one would probably believe it, but this is why you need a lawyer. There's a million reasons why you need a lawyer for an order of protection. But as Steve was saying, you could do something irrational or have a lapse of judgment and think that, there's no way to win. And if you don't know this law, which is so nuanced, and why Steve specializes in this, the story about getting one dismissed over the gun, the point of the gun.
Oh, yeah.
That's huge. No one would think you would win that one.
I took a case up on appeal where a neighbor literally pointed a gun at his neighbor. But in that case, the neighbor never testified that she took that seriously, which you would probably normally infer from those circumstances, but never testified that she was in fear of physical harm. Well, that is one of the requirements. A petitioner must prove that they were in fear of physical harm. There's both a subjective and an objective component behind it. In that particular case, we appealed it to the Missouri Court of Appeals Eastern District, and it was reversed, and we were successful on appeal because of that. When I'm looking on appeals and looking through a trial transcript, I'm almost always able to find issues that have merit to bring forth to contest the entry of the order of protection on appeal. It doesn't mean we're always successful, but like I said, we're probably about 50% on appeals.
Which the general rate on successful appeals in the criminal world is less than 2%,
I mean,
probably?
easily less than that.
Wow.
And so, You know, it's take that as a coin flip, really, right? And so, when I'm reading the transcripts on an appeal, I can almost always find issues that have merit that we can bring forward to challenge the entry of that order of protection. And again, doesn't mean we're always successful, but we're able to find these various issues to challenge it.
Now, speaking to challenging an order of protection, say they call properly, and don't wait.
Sure.
With the hopes to appeal. What kind of evidence do you need to challenge an order of protection?
Sure. Well, first off, you got to start with this premise. It is the petitioner that filed the case. So it's the petitioner's burden of proof. And what I mean by that is the petitioner, we don't have to do anything. We do, of course, and we challenge the credibility of the petitioner in the veracity of their testimony as well. But that said, the petitioner has the burden of proof, and the burden in these cases by preponderance of the evidence, which in layman's terms mean more likely than not. 51%, I believe, 49, I don't. Well, that's good enough. You met the burden of preponderance of the evidence. If you're looking at like a scale, if it's tilted slightly in favor.
It's just enough.
Correct.
Yeah.
So whereas in the criminal world, beyond a reasonable doubt, that's a very high standard. It's not that in these cases. So you start with that basic premise that a petitioner has the burden of proof. And how we challenge these at a hearing is almost always twofold. It's credibility and the veracity. We are challenging that this petitioner is not credible, and in many cases, these things turn on text messages. It turns on emails, things like that, where we can refute their testimony, show them that they're not credible, and furthermore, show that the statements that they're alleging or they're saying that our client did are not truthful. And you'll see a lot of this in this arena. Sadly, this area of law, it doesn't take much in terms of going. You can walk into the courthouse. I always joke about this and tell folks that I could walk into the courthouse after we are done with this. I can walk in there and say, my wife hit me on the head with a frying pan last night at dinner. And guess what? She will be served with an order of protection. She'll be ordered to leave the house because she'll have a foot restriction, right?
Sure.
And that'll be a temporary order until a hearing is set, which is usually 2 to 3 weeks down the road. And she's out of that, just like that. And I could completely fabricate, and these are, in many of these cases, these are fabricated allegations because for whatever reason, a boyfriend-girlfriend dispute, cheating, financial stuff, neighbors that are feuding. You see that commonly.
Well, it's fueled by emotion.
It is. And they do it in the heat of in the moment, typically. A lot of times cops get called on domestic cases, and there's not enough evidence to make an arrest. And what do cops will routinely tell people, go file an order of protection. It kind of punts it off of their radar.
Sure.
Sends it to the court. They're not involved. Hey, we don't have enough here to arrest. Go file an order of protection. And it's kind of wiping their hands clean of it, right? Mm-hmm. They put it in the court, let a judge make a decision. They're not involved in this. And so that's how these things get triggered in many cases. A lot of times when folks learn of this process, it's ripe to be abused. Hey, I just can go down to the courthouse or the police station and fill out this form.
It's terrifying.
Like I said, it is.
Yeah.
I always say to people, I say, I could literally use that analogy all the time and say, I can walk in there, say, my wife did this last night at dinner, hit me on the head. Here you go, ma'am. She's served. She's out of the house until that hearing date. It's scary. But back to the initial question, it was we challenge the credibility and we challenge the truthfulness of their statements.
Is it fair to say that a number of these are based solely on testimony?
Yes, and that's also scary because not every case has something to refute their credibility, and you get a petitioner that's intelligent and that is emotional and it cries and does all that at a hearing. These judges on a close case, I always say they will likely err on the side of caution and enter the order of protection. Because God forbid they don't enter the order of protection and, something happens a week later, right. One of them kills one of them, and the Post-Dispatch is writing about this, and what they're going to do is go, why didn't that judge enter that order of protection? So on a close case, I always say they're likely going to enter the order of protection. Again, credibility and the veracity of their statements is how we attack these. That's what's critical.
Cross-examination is
And
what
that's
it's
how we
all
do
about.
it, is through
Yeah.
cross-examination. And so, but the thing to know about these, and clients routinely say, well, she doesn't have any evidence. And I always say testimony is evidence. You know, we live in such a world where we think, hey, if you don't have DNA, if it's a sex assault case, or, you know, you don't have pictures of injuries, or you don't have text message proof or recordings of these threats allegedly made, you know, a petitioner does not need that. They can literally just go in there and say, this is what happened. Now, does that help? Yes, of course it does. Does that bolster their case? Yes, of course it does. But they don't have to have physical evidence in the form of pictures, recordings, text messages, emails, things like that.
And Steve, that's something we see across the board, not just in order protections, but in criminal defense, is in general criminal defense is, you know, I even deal with it, and I don't handle orders of protection, but there are many times that clients say there's no evidence, and, you know, without being callous, you know, I try to explain to them, there's people sitting in prison all across the country for the rest of their life based on what someone testified to in court. So again, with the modern day CSI, everyone thinks there's got to be, you know, some type of physical evidence, but testimony is evidence. And that's a critical thing to take away from this.
The preponderance of hearsay. Jeez. So I know you touched on what happens if, you know, you receive this order of protection. So what specifically, or how long does an order of protection last?
1 year. And the judge can do a minimum of 180 days, all the way up to 10 years. Most common is 1 year.
Okay.
And they can do 1 year with an automatic renewal for 1 year. And then in cases like I previously said that are very egregious, they can do it up to 10 years if they make certain written specific findings. But the common time period is 1 year.
1 year. So it doesn't loosen the restraints of that.
No,
order
I
of
mean,
protection.
that's a court order that, like I said, prohibits you from communicating in any medium through any third party, from contacting that person, disturbing their peace, going near them. You know, there's cases where, you know, you might have children on the same soccer team. You know, I've seen all of that where, hey, I can't go to my kid's soccer game now because this other parent filed this order of protection, and our kids play on the same soccer team, or they're in the same school, you know, and I can't go to the bus stop because I know. And so, you know, while the person may not want any contact communication anyway, it can impede their own life depending on the dynamic of who filed this. You know, a lot of times family members file these. You'll see it common within families, not just husband, wife, or boyfriend, girlfriend, but, you know, brother-in-law or cousin or son. I've seen them all. You know, okay, now how do you navigate Thanksgiving? You know, I can't be there because so-and-so is going to be there. Or you see these in small towns. You know, we represent folks all across Missouri, you know, where, hey, there's only 3 restaurants, bars in town. And I have an order that says I can't go around John Smith. Well, John Smith, you know, frequents these spots. Now so it impedes my own life and my own enjoyment and of where I can maybe go, especially, like I said, when you're in these small towns.
And Steve, how does the law work on that? Meaning if someone has a full order of protection of you, or someone has a full order of protection against you, and you bump into them at church or the grocery store.
I mean, you have an obligation to leave. I always tell my clients, I mean, you can't predict where somebody's going to be, you know, so if you have an order of protection against me, judge signed it, it's in place for 1 year, and you're walking through Straub's, and, you know, I'm in there toting my cart along, well, I see you. This is a one-way street. You don't have to leave. You're the one with the order of protection against me. It's my obligation. I'm the one that has court orders saying I can't be around you. So, you know, I'd have to up and leave. You know,
How is that? How's that managed? You know, you run into somebody. Are you breaking the law?
You're not. And I always tell clients is that you can't predict. I can't predict where you're going to be, right? I can't predict when you're going to the grocery store, when you go to the gym, you know, when you go to the you know, Walgreens, things like that.
Yeah.
It rarely comes into play in St. Louis because it's a bigger city, obviously, and the county's large. you'll see it in the small towns. I represented folks in a case that comes to mind, Hannibal, Crawford County, Steelville, Cuba. These kind of towns have, one little downtown with 3 restaurants, one drugstore. You're going to bump into people.
Right.
And so that's another reason. Now, again, it impedes your own life and your own enjoyment of life. But the obligation would be on the person who the order is against.
Sure.
You have no obligation to get up and leave. If I saw you, I'm sitting down for dinner and you walk in, well, guess what? I better pack up, pay my bill, and leave. Now, I'm not breaking the law unless I kind of stick around. I mean, I've never had a client arrested and said, you accidentally bumped into this person, when it was truly that.
Right.
Generally speaking, it's a common sense approach.
But
But again, the obligation is for me, under that hypothetical, the obligation is for me to leave.
This reiterates the nuances of orders of protection.
Sorry, I didn't mean to talk.
No, it's okay.
One quick comment is, not just the ramifications of having a full order of protection entered against you, like we already discussed, but once there's a full order entered against you, if you break that, you're looking at a criminal charge of violating an order of protection. So, again, people think, I don't care if I ever talk to that person again, but again, you violate that thing, here comes a criminal charge. And so it can really build on itself and become a big deal.
And that's a great point, because these two people are feuding, they're at odds, right? Mm-hmm. And the full order of protection, if it's granted after a hearing, just what Chris said, now that person can call, hey, he drove by my house. And that's usually enough to get that person arrested, which is scary. Now they have a misdemeanor for violating an order of protection. I always say these things can weaponize a petitioner.
Yeah.
You get a boyfriend, girlfriend that are not that the girlfriend files the order of protection against the boyfriend. She can't stand him. She gets that full order of protection. I mean, in many times these people, it weaponizes them in the sense that, okay, now I got this piece of paper here in my pocket. I'm going to call, hey, guess what? He showed up at this party and didn't leave. He drove by my house. I saw his car drive through. I have a ring cam, and so you see all that, and it absolutely, we represent folks all the time on violating an order of protection. So that's another big reason that despite what your feelings are for the petitioner, again, you usually aren't calling our office saying, hey, I want to still talk to that person. You're fighting this thing for a number of reasons, and that's another big one, is what Chris said, is that you don't want the full order of protection entered, but you also don't want to weaponize that petitioner to make it easy for you to get arrested.
Sounds really complicated.
Yes, it can be. I mean, you get yourself entangled in one of these. I've seen it where they get the order of protection. A client gets one against them. They call us, and it's, I've represented a number of violations because he sent me a text message, and it's easy to manipulate that and to make it look and appear as if that person's the one sending text. And you can get yourself in a whole web of judicial proceedings as a result of the single order of protection.
Well, let's say I'm the respondent. I receive I'm served an order of protection. I mean, the first thing I want to do, if I think it's not true, is contact the person that filed the order of protection.
Regardless if it's true or not true, you call our office. And you do it quickly. Too many folks wait. They don't want to look at it because it's too unpleasant, perhaps. I hear that all the time. Well, I just set it aside. I couldn't look at it. I didn't really care. She's out of my life. He's out of my life. And all of a sudden they look at it and their hearing date's 2 days away. Get calls all the time, day before, 2 days, 3 days before the hearing. So you get served, whether it's truthful, whether it's a bunch of lies, you call us, because then we can get you into our office. We can meet, discuss this, and get to work, because these cases move quickly. And you're probably, when the time you were served, you're going to have a hearing within a week to 2 weeks on that notice that you'll get.
And by hearing, he means a full-blown trial. I mean, not with a jury, but go ahead.
Yeah, the hearing is to determine whether the full order is granted, where we present evidence. And so there's a lot to do in a little bit of the time. I always tell folks, there's a lot to do, but we do this so often that we have a system in place and we can do that. But you put yourself in a much better position by calling an attorney right away. Don't get served, put it on the coffee table for a week and then take a peek at it, and then it's, hey, it's 6 p.m. and I got court at 9 a.m. the next day. There's some judges that won't do continuances, and that's a whole nother deal. So you get served, you call us right away because we'll get you in our office, walk you through this process, talk about those allegations, get ourselves prepared for the hearing, get our client prepared to testify. Mm-hmm. I always bring my client in to get their testimony, kind of walk them through what my questions are going to be. I always give them tips and kind of give them a little bit of a preview of what a cross-examination will look like, because each party will be subjected to petitioner and respondent will both be subjected to cross-examination. It's paramount when you walk into a courtroom for a hearing, for anything. It's paramount that you are as prepared as you possibly can be. It's paramount and critical that your client is as prepared as he or she can possibly be. They're going to be more comfortable. They're going to come off more credible. When they are comfortable, you're going to come off as more authentic, more genuine, versus, it's okay to be nervous. Everyone is nervous when they walk into court. Yeah. But it's our job, my job as their lawyer, is that they are as prepared as they possibly can be. That they are ready for cross-examination because I've walked them through what that's going to look like.
Is there a timeline of which, when you're served, can I call the person that filed the order of protection? At which point I'm served with it, can I call them?
Call the person
that ordered the petitioner.
Because you're going to have a temporary order and they're saying not to communicate or contact.
Even if you don't look at it?
Yes. As soon as you're served, you're put on notice.
As soon as it's set in front of you.
Once that's served to you, whether you looked at it, threw it away, burned it, you're on notice, and that's your responsibility. And at that point, I get that a lot where folks want to call that person to resolve it. Well, once you're served, to do what you just said, to call, maybe it's your ex-girlfriend. I want to just call her and say, come on, let's just put all this aside. I'm really sorry now. I won't have any more. No, that's a violation. You can be arrested for that. Whether you read it or not, it's your responsibility because you were put on notice. You were officially served.
And I'll let Steve correct me if I'm wrong, but I think the majority, and I don't know the percentage, are served as ex parte, which means they've only heard from one side. But that means it's in effect as soon as you are served until they hear from both parties at a hearing. So I don't know what percentage are served with ex partes.
Yeah,
it is effective immediately upon being served.
Correct. And there's two ways, without getting too into the weeds on this, there's two. You could have an ex parte order. That's what Chris said, an immediate order saying no communication, no contact, can't be within 500,000 feet. Or the court can simply issue you a summons to appear for the hearing and didn't issue any temporary orders. In that case, you could technically call the petitioner. I wouldn't suggest doing that, especially with pending litigation. It's my advice, if you are served, whether it's BS or whether it's truthful, whether it's by an ex parte or by some notice of hearing or summons, you call an attorney, get yourself ready for the hearing, and start getting the wheels in motion on that.
Let's say I do make the call. What happens to me if I violate an order of protection?
Your first offense, it's a Class A misdemeanor. You will be, in many of these cases, they'll issue a warrant because they take these things very seriously. Because you're basically, the whole crux of that is that you are already violating a court's order, a judge's order. So despite it only being a misdemeanor, in many of these cases, they will issue a warrant for an arrest. Where, a bond amount, you can be arrested, taken in, you'll have to argue the bond to get reduced. And so courts treat these things very, very seriously because again, think about this. You are already you're spitting on an order of the court. The judge has ordered you to not do something, and you are doing it in direct violation of that that judge's order, that court's order. So they treat these things very seriously. So the first two offenses are Class A misdemeanors, and the third offense will be charged as a felony offense.
I mean, relationships, often this is within the confines of a relationship.
Right.
Let's say it's frivolous. He just do this all the time, just exaggerating. Do I really need an attorney
Absolutely.
to fight an order?
Absolutely. Without a doubt. You know, would I do my own surgery? You know, if I needed a knee replacement, I wouldn't do that myself, right? Would you walk into a courtroom with this much at stake, with no legal background, no legal training? Now, can you do it? Yeah, and I'm in these dockets all the time, and I watch folks do it, and it's cringe. I mean, you're going, ugh, you know, this poor guy or poor woman, you know, they don't know how to make correct objections, and you're held to the same standard as an attorney. So when you walk in that courtroom, this isn't, you know, Judge Judy where anything goes, and, you know,
Rules of evidence don't apply. I mean, I saw this today in court, just real quick, Steve, sorry to talk over you, but I was in court today, and someone was representing themselves, and the judge said, well, this is set for trial now, and the person said, well, I'm going to represent myself, and the judge said, well, you're not going to understand the rules of evidence and how to get your evidence in,
right.
And if the other party's attorney objects to something, and I sustain that objection, you know, I mean, again, you're not going to understand the nuances.
That's terrifying.
You can't go at it alone. You just can't.
Well, how can I get an order of protection dismissed?
Dismissed is, we usually, as the respondent, don't have that ability. I shouldn't say, there are some situations or some courts that allow us to file motion to dismiss. But I always tell the respondent when they call us, you know, our options are twofold, basically. Is number one, you either consent to this, which they're not calling me to consent. They could go walk in the courtroom and sign a piece of paper saying, no hearing, I agree with the order of protection, right? That's what a consent is. But their two options are basically consent or have a hearing. And so, if they're calling my office and they're calling us for representation, usually they're not consenting. There are a small percentage of cases where the evidence may be just so overwhelming that we would advise our client in those situations to consent and let's try to mitigate this. We don't want to have a hearing. Maybe there's also a criminal case at play because they've been charged with domestic assault, and we don't want our client testifying. So there are some situations in which we would advise our client to consent, but by and large, if they're calling us and they're hiring us, you know, they're not interested in a consent. They're wanting to fight this, and that's what we do. And so, as far as the question getting it dismissed, we don't have that control. The petitioner does. They are the one who filed the order of protection. Oh. Only they can dismiss this. You know, we have to be ready to walk in there, and I always tell our clients is, you hire us, this court date is on, 2 weeks from now, we're going to be ready to rock and roll. We're going to walk in there ready for a hearing and ready to, cross-examine the petitioner, put on the testimony of our client, the respondent, and we're going to be ready for a hearing. So we don't necessarily control the dismissal. Petitioner does, and that happens from time to time. And I'm allowed to talk with the petitioner, and sometimes I'm able to talk the petitioner into a dismissal. But at the end of the day, the petitioner controls that.
And there's just quickly, there are a lot of strategies I've just seen him, execute that I would have never thought of. And again, why I don't handle orders of protection. But you get served, and that ex parte is in place. I've seen Steve negotiate where, let's keep the ex parte in place for 6 months. If no issue, then would you dismiss? So there's all kinds of different strategies that, Steve, utilizes. That, again, if you don't do this day in and day out, you're not going to know that's even an option. So.
Right. How does an order of protection affect custody rights?
So there's what we haven't touched on yet is there's two different kinds of orders of protection. There's an adult versus adult, right? That's you filing one versus me. Okay, and then we also have child orders of protection. That is you filing on behalf of your child. And so an adult would be the named petitioner, filing on behalf of their child. And those are the ones that typically have custody consequences. If there's not a custodial order, there's not an order for custody in place, that judge, at the conclusion of the hearing, could determine custody. And obviously, if somebody is alleged and accused and proven to be somebody who has beat, abused, neglected a child, well, that petitioner is probably going to get custody, and whereas the respondent may only have supervised visits. And so in the child order protection context, in that case, if there's children at play, that's where the custody comes in, and that a judge in the order protection case can determine and order custody to one individual over the other.
Seems very subjective.
It is. It is. But they still have to, again, the petitioner still has to prove their case and be the prevailing party, to in effect get custody.
It's very technical, wouldn't you agree?
Yes. It's an area of law that a lot of folks, and you see this, it's scary, you see this amongst attorneys too, that don't handle these cases, but may take one on because it's, a client, a client that they're handling a different matter for gets served with one, or, hey, my neighbor, my kid's friend, and they come into the courtroom and they don't know what the law is. They can't define what stalking is versus harassment. And that's scary. You see a lot of lawyers that come in and just do maybe a case. And that's scary, because I'm going, how do you effectively defend one of these when you can't define what stalking or harassment are? There's different avenues certain people can pursue these under versus stalking versus harassment. And again, getting pretty technical, but that's a whole nother seminar on of its own. But you'll have lawyers that waltz into court and think, hey, and can't define those two terms, which is pretty scary that they're defending somebody on one of these.
Can I have an order of protection removed from my record?
You can't.
Never.
No. Currently, there's nothing in place right now. We get quite a few phone calls asking that because, hey, didn't care about it when I was served, didn't care about that person 4 years down the road, and we get a handful of calls each week about this very issue. But now they went and applied for a job, or they want to drive the school bus, or they want to get a background check to be, coach their kids.
Go on a field trip.
And they go, well, you can't because that order of protection. Wow. Even though it may not be valid because, we have, typically are going to be in place for 1 year. But even after that 1 year period is up, it still shows, it's still a red flag that somebody was an abuser, was a stalker, was somebody harassing another person. So it's a red flag. So there's major consequences across the board on these things.
What should I expect at a hearing for an order of protection?
It's a hearing, depending on the judge, there tend to be a little bit more informal. But that said, the full rules of evidence apply. They should be, what I always tell our client is, number one is behave appropriately. No demonstrative gestures, no shaking of the head, rolling your eyes or scoffing when you hear the other person testify. I drill that into the head because you're in a courtroom, there's a sense of respect and decorum. And I've won cases and lost cases where it was based solely on my client's behavior, or vice versa. We've won them because that person was acting like a jerk, acting like an idiot in court, and they lose their credibility. So that's number one. Number two is be prepared, and we're going to have you prepared. You're going to be prepared to testify. You're going to be prepared to stand up to cross-examination. And so those are those things when we take on a case, our client will be prepared for that. It's not only their testimony and their cross-examination. And then the client and I work kind of collaboratively together as the hearing date approaches to gather evidence. I usually get text messages. We all, sometimes Snapchats, emails, voicemails. Those tend to come into play in many of these cases. And so we are going to collect anything that we believe is going to be beneficial and helpful for our case and to rebut these allegations that are lodged against
social media too.
Social media, Facebook posts, Instagram stuff.
What's the difference between a restraining order and an order of protection?
There isn't. It's the technical, the legal term is order of protection. What the public commonly knows them as is restraining order, but there's no difference. They are one of the same.
Can I prove that an order of protection was made on false allegations?
Yeah, and we do that, like I said, through accumulating evidence and working collaboratively with our client. I always tell our clients is I want anything that you might that can discredit. Almost always, the respondent is saying this is a lie, this is embellished, and with technology in our society and the prevalence of phones, these typically, that's why social media, the text, the recordings come into play, and why we collaboratively work with our client to collect anything that we think are going to discredit those allegations or prove those allegations are false.
And and I've been at the office and I've seen a stack of text messages this big get printed out, and Steve goes through them painstakingly. I mean, it's just what it takes.
Wow. What if if I were the petitioner and I just want to drop it? I just want to drop the order of protection.
And you can, and you'd either, there's a couple ways. A lot of times the petitioners just don't show up to court. I've been there and appeared, we're ready for a hearing, we show up, and the petitioner just doesn't show up. And those are typically petitioners that know this process and kind of use it and abuse it as well. There's times when petitioner may hire a lawyer, they call me, we kind of work out a resolution. That's not entirely uncommon, where, hey, they'll dismiss this, kind of based on our assurances that, listen, I talked to my client, this thing woke him up or her up, and, I'm rest assured there's going to be no more issues. So, or I've had petitioners on cases of mine that just simply walk down to the court, walk into the courthouse, fill out a memo saying, I changed my mind, I'm dismissing this. You'll see that in a lot of relationships. Maybe they kiss and make up, and the girlfriend or boyfriend goes in the courthouse and says, I don't want to go through with this. So it doesn't take a whole lot, and it can be done.
During the period of an order of protection, can I make modifications?
As the petitioner or respondent?
Either one.
Petitioner, respondent can request them. They typically aren't going to be granted unless there's some very, very compelling reasons. Sometimes in the situation of, hey, I want to go to my kid's soccer game, but that lady who has an order of protection against me, well, we're requesting that, my client be allowed to be at that game, or the school functions when they have a child in common. So respondents can make those requests under those kind of compelling, unique circumstances. Petitioners can do it as well, but rarely does a petitioner go in and request her own or his own order of protection to be modified, but they can be done.
How does an order of protection affect my job or my home?
Yeah, background checks. Every job is different. Of course, the higher you go up in society, the more thorough and extensive the background check. Background checks are different at 7-Eleven than they are at Boeing.
But all this takes is a CaseNet search.
Correct. So that's number one. But then, because once you get a full order of protection granted, that's going to be on CaseNet. But let's say beyond the period of time that it's in effect, again, the higher you go up in society, the more thorough that background check is going to be. If you're going to apply for Boeing, I'm sure they're going to see that, hey, 8 years ago, you had an order of protection against you, and let's talk about that. And that's going to raise red flags in terms of employment. It's too high. Jobs are too competitive these days to put yourself at that kind of a disadvantage walking in with a red flag already. You better be one hell of a candidate to overcome that, right? There's just, these jobs are too competitive. There's other employees or candidates, I should say, that, might not have that red flag that's going to be the difference in getting that job, getting that promotion, getting that security clearance. That has an impact too. Folks that have high security clearance for jobs. I've represented, folks in the Army. I've represented folks that professors, students, police officers even. I've represented, almost every walk of life in these proceedings. And so it absolutely has an impact on employment.
What about housing?
Housing, it can. You don't hear it as often as the employment, but, landlords run checks, apartments run checks. Once again, it's a competitive. These apartments are full. They have other candidates. Why the hassle with this person when they've been labeled an abuser or a stalker? So it can, absolutely. Again, we don't hear it as often as the employment context, but it absolutely can have an impact, when the landlord's running a check, a credit check, a background check, and a CaseNet check, and that thing pops up. Well, I'm not going to deal with that person. I'll take this guy or gal. She doesn't have any red flags. Right. Same thing.
What do I do if I'm falsely accused of an order of protection?
Call us.
Yeah.
So we can fight it.
Yeah.
And, that's what it takes. I mean, these cases are kind of all or nothing. There's not like a middle ground, really. They either dismiss this thing, you can consent to it, and there's our very, small percentage of cases where we do or we advise our client. But these are generally all or nothing cases. What I mean is that, hey, we're going to a hearing, or they're dismissing it, which we don't control that as the respondent. So if they don't dismiss it, we have one option: either consent or go to a hearing. And if they're calling us and we're representing them, almost every single time we're going to a hearing.
Well, let's say we're going to the hearings. Well, how do I prepare for that? How do
That's
I
through
prepare
us.
for an order?
You're working collaboratively. You hire me to handle your case. We're working collaboratively together to get you prepared and accumulating evidence, collecting evidence from you that are going to help rebut these allegations, to help show that the petitioner's not credible, to help show that these allegations are false.
And do you recommend, because like you say, most of the cases that you take on are respondents, correct?
Correct.
So do you recommend a petitioner get an attorney as well?
Again, I think it's always wise walking into a courtroom. I think you're going to put yourself in a much better position. For instance, I'll say it I'll kind of use the inverse of that, the converse, I should say. If I'm representing a respondent and I'm going against a pro se petitioner, that just made my life a lot easier, right? I don't have an attorney that knows the law, that knows how to lay the foundation for evidence, that knows how to object properly at what things that I may be doing or saying. So if I'm going against Joe Smith, pro se, no lawyer, my job got a whole lot easier, right? Now if I know that there's a skilled attorney, reputable, good attorney that's representing the petitioner, that's going to make my job harder. So, again, you go into a courtroom and you're not a lawyer and you don't have formal legal training, you're at a significant disadvantage versus walking in with a lawyer who knows what they're doing, knows the law. You're putting yourself in a much better position. So even as a petitioner, and you may have been abused, stalked, harassed, sexually assaulted, it would still be wise, because how do I get these pictures into evidence? How do I get this video into evidence? Those are technical evidentiary issues that we have been trained as lawyers to do. It's not simply, hey, here's my phone. Some judges might give you a little bit more latitude and do it, but it's not worth the risk. Even petitioners, I would advise to get an attorney. And we do represent petitioners from time to time, I should say. But probably 90%, 95% of what we do is on the respondent side. So I have represented petitioners. Those are the folks seeking to get an order of protection. And again, they're at a significant advantage walking in with an attorney.
Well, how subjective and the nuances and all this sounds terrifying for anyone, either petitioning or responding, to an order of protection and leaving all of that in the hands of a judge if you don't arm yourself with the right kind of protection, which is you guys. So, you know, there's a reason that we have these conversations, and every time we have these conversations, I always walk away thinking, man, I just feel better. Like, I'm not in a situation that I need to call about this, but boy, when I get there, if I get there and when that moment occurs, I feel the safety net can be thrown. So it's nice. I really appreciate you guys coming out to talk about this. This is a delicate subject, and I'm grateful that we had this conversation.
Absolutely. Enjoyed it.